All right, I'm gonna address something, and I'm gonna tell you something. I did a video a while ago, and I did a video talking about why you do not need an attorney or why you do not need a lawyer. And this video got trolled so much, I almost had to take it down. There was an attorney who was out of Seattle, not Seattle, I'm sorry, San Diego, who trolled me so much that I took the video down. But I wanted to go at it because at the time, my mind was a little different. Um, And when you're talking about attorneys, most people do not understand what an attorney's actual role is. So when you're talking about attorneys, there's a lot of people, oh, attorneys is corrupt and blah, 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 blah. Well, I'm going to tell you from my experience why you don't need an attorney in most instances. But the problem with people is they don't want to learn law ahead of time. That's why it puts them in a precarious situation of where they need an attorney. All right, so I'm gonna start with my fragrance today, which is Harriet from Perfumes de Marley. I'm glad I got the batch before they got sold out. I mean, or bought out. So we're gonna talk. Everybody knows America. Corpus Juris Secundum 7, Section 4. Okay, everybody knows this. Okay, and I'm gonna tell you why attorneys are not evil, but I'm gonna tell you why you do not need them. Okay, when you get to an attorney and when you trust somebody else to handle your affairs, you better be sure that that person is very trustworthy. And when it comes to an attorney, it's not always that attorneys are, their allegiance with the bar and all this other, stuff that people tell you. What it is your attorney may be incompetent. They just may not know what to do. That's why you always have to know law more than an attorney. I'm not saying that you can't use an attorney because if you have a court case. And like, say if I have a court case out of state, I'm not appearing at that. So I can hire an attorney and say, hey, go up here, give them jurisdiction, and then file my motion and dismiss it. But I know how to use an attorney in a certain way that you may not know how. But we'll go over corpus juris secundum. So you'll kind of understand the relation of attorney. So attorney and client, subsection 4. His first duty is to the courts and the public, not the client. And whenever the duties to his client conflict with those he owes as an officer of the court in, in administration of justice, the former must yield to the latter. So from that, we can take it as the attorney's first duty is to the court. Okay. So when people get this, they read this, they say, oh, well, yeah, your attorney's duty is to the client. No, the duty of the attorney is to the court, meaning their duty is to, you know, process these cases through the court, follow the court rules, because that's why you have an attorney, because an attorney is supposed to know the local rules. Well, you may not know them. The attorney is supposed to know them. So that's why they're saying the duty is to the court first and not the client. Now, we know that these courts are private courts. We know that they're private trading organizations. We know that they're all private. But what the attorney is not may not be as nefarious as you think they are. And I know everybody's like, oh, they're all out to take your money and all this other stuff. Okay. And I'm not siding with the attorney. I'm just telling you from my experience of being in a lot of foreclosures that most attorneys are incompetent. I'm just going to be honest with you. So let's go to the American Bar Association and kind of look at their duties. Okay, so that juris secundum is kind of old and outdated. So this is basically a preamble, lawyers' responsibilities, and it'll tell you in here that the lawyers or the basically the lawyers are self-governing, or the basically I'll go over it with you. Okay, a lawyer's responsibility. A lawyer, as a member of the legal profession, is a representative of clients and an officer of the legal system. Okay, so in that instance, if I'm going to hire a lawyer, I'm not going to use a lawyer for trial. Now, I may use a lawyer to file a motion for me, but why would I use him when he's a part of the legal system? Now, this is the big confliction, or this is where things conflict. Because if he's a part of the legal system, the same legal system that is trying to incarcerate me, okay, he becomes an agent in that system. So I don't know where his loyalty aligns. Okay, so it's not just because he's a lawyer; it's because he's a human being. You can be, when it comes to humans, a human could turn on you any minute. You know what I'm saying? I remember one time I had a trial, and it was in Jacksonville, and we had this foreclosure trial, and my lawyer turned on me in the trial, turned on me, and the judge was just playing with me. But the lawyer turned on me in trial, and I was his witness. The same lawyer turned on me in Miami. Wait, was it Miami? I think it was Sanford and West Palm Beach. He turned on me in 3 trials. The guy was very incompetent. You know what I'm saying? But he was good at playing dumb too. So look, and a public citizen having a special responsibility for the quality of justice. Okay. As a representative of clients, a lawyer performs various functions. So what I try to tell you guys is you always want to find out your information from the horse's mouth, not the horse's ass. Just because somebody says something, right, and they have their presumptions, go look at what their duties are to the client. So if you do have a lawyer, you can hold him liable for what he's done too. So say if you had a lawyer and you're going to bring up what most people bring up, which is inefficiency of counsel. So most people bring this up with their attorney. So when you're dealing with an attorney, okay, kind of messed that up. I was trying to bring up something and I actually lost it. But some ineffectiveness of counsel, or when you hire an attorney and they may not be competent, you can actually go back and get your case reopened because the attorney was incompetent or the attorney failed to disclose certain things to you. So, some people say, attorney gives a court jurisdiction. So what? It doesn't matter. It really doesn't matter in the grand scheme of things, because if the attorney was ineffective or the attorney failed to disclose evidence or information that you should have been privy to make decisions, that's also a way. That's also something you can use in affirmative defense. Okay, so you want to know your affirmative defenses when you're going into trial. And I'm not telling you that attorneys are bad people. So if attorneys start trolling this video, I'm not saying that. I'm saying that most attorneys do not know the law. Okay, you always want to know your affirmative defenses if you're going into court. And you can actually hire an attorney to go in there for you. But make sure that make sure you put the clamps on them and don't let them, walk around freely to do whatever they want. That's what most people do. You hire an attorney because you're thinking the attorney is supposed to represent you, and the attorney goes into court and you haven't given him any orders to represent you. Attorneys will ask you questions about motions and things, and you don't know, so you don't know what a good motion looks like. So when an attorney goes into court, you're going to be like, oh man, this attorney did me dirty, and it's really you did yourself dirty because you didn't give the attorney you didn't give him authority, and you didn't tell him what to do in court. So an affirmative defense is in which the defendant introduces evidence which, if found to be credible, will negate criminal liability or civil liability, even if it is proven that the defendant committed the alleged acts. Okay, so if you understand this, right, you understand what an affirmative defense is. You'll be in a better state of somebody who doesn't understand that. Okay, so what people do is they go into court, they don't know what they're doing, they never raise an affirmative defense, and then the judge runs all over them. And then they look at the judge, it's like, oh, the judge is corrupt, the court is corrupt. And it's not always that the judge is corrupt. It's if you don't give the judge something to rule on, he only can rule on what the plaintiff put into court. Okay, so when you raise a civil affirmative defense, we'll go back over that again so you understand that just by raising an affirmative defense, it basically will save you from long drawn out litigation, or it can save you from going to jail, or it can save you from getting your house taken, etc. So an affirmative defense is a defense in which the defendant introduces evidence which, if found to be credible, will negate criminal liability or civil liability, even if it is proven that the defendant committed the alleged acts. Now, most of you guys go to court and you're so scared to go into court and challenge what's on the record because everybody told you all this: appoint the judge as the trustee, GSA bonds. They told you all this stuff when all you have to do is raise an affirmative defense. It says it right here. Okay. So look, the party raising the affirmative defense has the burden of proof on establishing that it applies. That's it. That's all you have to do. That's all you have. You don't have the burden of proof to prove the claim. You have the burden of proof to that the affirmative defense that you're alleging applies to your case. Okay? Raising an affirmative defense does not prevent a party from also raising other defenses. Okay? Self-defense, entrapment, insanity, necessity, and respondent superior are some of the examples of affirmative defenses. See, they're not going to give you all of them because, I mean, obviously, then you wouldn't need an attorney. So look, under federal rules of civil procedure, Rule 56, any party may make a motion for summary judgment on an affirmative defense. Okay? So now what you need to understand is that when you're making an affirmative defense, what you're doing is you're correcting the record, or you're challenging the record, or not even challenging the record. You're raising a defense to what you did. So, like, say if somebody said I was speeding, or somebody said I was under the influence, I may have an affirmative defense to say that I may have been under the influence, but the traffic stop was illegal. You see what I'm saying? So now you understand that some of these attorneys don't know that. Now you might say, why would an attorney not know that? Just because an attorney has 10, 20, 30 years in the practice, it does not mean that the attorney actually goes to court. Okay. In that 10, 20 years, right, you have to look at what the conviction rate of most courts are. So let's see. So we'll see. So the conviction rate is between the United States, oh, that's the federal court system. So it's approximately between 80%, 85%. Okay, let me tell you why. When most people catch a Fed case, they tend to cop out because they don't know any better. So in the United States, let's see what it is in the United States. Okay, so it says around 73%. So I don't know where people are getting this federal court conviction at like 90% or 80%. Let's see. Where does it say that? Okay, so yeah, what you should know about the federal government's conviction rate. Prosecutors have a 99.6. That's bullshit. I'm telling you 100% that's bullshit. When you control the statistics, you can make them to be whatever you want. But the reason why most people lose in court is because they don't go to trial, or they don't know how to structure a court case, how to answer a complaint, how to challenge certain authority, or challenge certain things like competency. And I have a lot of things on this channel that'll help you with that. So if you're going to court, there's certain things I'm going to bring up. I'm going to do probably one more law class, And then that's probably going to be my magnum opus of law classes. But see, when people sit there and say, oh, don't go into court arguing. Okay, that's great. That's a great thing. You don't want to go into court argument, but you don't want to go into court and let the court railroad you also. So when you're hiring these attorneys, we know what their duty is out of corpus juris secundum. Also, this is a good publication. This is a Marquette Law Review in regards to attorneys and their duties. So, attorney-client, attorney discipline for extra professional conduct. After a defendant failed to file a state income tax returns for 2 consecutive years, he was tried and convicted under Section 711, 771.1142 of the Wisconsin statutes. The Board of State Bar Commissioners then brought the instant action seeking disciplinary action by the Wisconsin Supreme Court. A court-appointed referee found no actual criminal intent, fraud, or moral turpitude, and recommended dismissal of the action. Disregarding the recommendation, the court affirmed the referee's finding, but held that the attorney's conduct warranted reprimand and ordered the defendant to pay costs and expenses of the proceeding not exceeding $750. Now, the reason why a court does this is because sometimes the court could be a damn jerk. The court is not trying to lose, so you have to understand when you're in court, the court is a business. So the court is trying to fund itself. Okay. So we'll go back to the ABA's website, and then we're talking about their legal rights, their obligation, explains their practical implications. As an advocate, a lawyer zealously asserts the client's position. See, the client's position. So as a client of a lawyer, you must have a position, meaning you must have knowledge within law, or you must have some sort of knowledge to convey with your lawyer. So the lawyer can't fully represent you if you don't know the law. So a lot of times when people say, oh man, a lawyer, blah, 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 blah. When a lawyer acts, or a lawyer, even if the lawyer doesn't do what you tell him to do, you still have an affirmative defense as long as you have a record of you sending him an email or sending him some sort of correspondence to do something. If the lawyer doesn't, he can be held liable too. So he's not going to be to a point where the lawyer is not liable. Okay. Under the rules of the adversarial system, as a negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealings with others. See? So what they're trying to say is that's why they do plea bargains. You see what I'm saying? So when you go into court, that's why the lawyer does plea bargains. So he's trying to do a win for the judge, for the court, and a win for his client, even though it really isn't. Okay, as an evaluator, a lawyer acts by examining clients' legal affairs and reporting about them to the clients or to others. In addition to these representational functions, a lawyer may serve as a third-party neutral, a non-representation role, helping parties to resolve a dispute or other matter. Some of these rules apply directly to lawyers who are or have served as third-party neutrals. See e.g. Rules 1.12 and 2.4. In addition, there are rules that apply to lawyers who are not active in the practice of law or to practicing lawyers, even when they are acting in a non-professional capacity. For example, a lawyer who commits fraud in the conduct of business is subject to discipline for engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Well, then that's every damn lawyer. See Rule 8.4. So if your lawyer is messed up, you can go after them through the bar. You can go after them civilly. And if the conduct is so bad, you can actually go after the lawyers criminally. in all professional functions, a lawyer should be competent. Okay. So what happens with a lot of lawyers uh, that I found dealing in the foreclosure trials, there was a big law firm, and I really don't want to bring up their name, but I will. They were a defense lawyer, and their name was Tickton. Okay. Tickton was a defense lawyer for, he was basically a defense lawyer for homeowners, right? But when I found out it was Tickton actually had his home foreclosed on. So it was kind of crazy to me, like, how are you a foreclosure defendant, or how you defend foreclosures, but you had your home foreclosed now? But some lawyers are not competent. So all his lawyers used to do is just go up in the court, and then they would just object, or they would just file crazy motions and do all things to prolong the case, but they never had an intention of winning. Now, the reason why lawyers do this is because they don't know how to win. I had a case one time, it was in Orlando, and this lawyer had pulled one of the best things that I've seen in a case. And what she did is, we went to court and we tried to settle this, but we couldn't, for the, when I was working for the bank. And she she challenged the signature on the note at the last minute. So the judge had to say, okay, we got to continue this. We had to have a handwriting specialist come in or whatever, and look this up, right? So it was crazy that the lawyer figured it out, but the person ended up still filing for bankruptcy. You see what I'm saying? So, like, the attorney they don't know how to get a house free and clear. If an attorney knew how to get a house free and clear, they wouldn't be a damn attorney. You see what I'm saying? So when you think about it, the attorney is not going through a foreclosure. Like, if somebody can't really give you guidance, and I'm not saying in all situations, but in most situations, if you've never been to court, and you're not putting yourself at risk, then you really can't give anybody guidance too much. Like, if you ain't never been thrown into jail, you ain't never been through shit, you really can't teach nobody nothing. And there's a lot of people on the internet who find some of this information, and they go on Scribd and other websites, or Scribe, whatever it's called, and they find this information, and they go get the UCC book, and they start telling you information like they know stuff. And they really don't, because a lot of people they haven't been through shit. So until you lose a car, lose a house, that's when you really get to see the system. That's when you're like, oh shit, the system works like this. It's not how I thought it was. So, competency. So a lawyer may may actually have 30 years practicing law. I got into it with a lawyer one time, and this lawyer tried to tell me that I could not move a municipal court case into a federal court. I beg to differ. I could move a court case in any court I want to, damn near, because I know how to do it. But he doesn't know, because he never did it. So what he does is, he's training off of what he learned, and that's it. He never expanded his knowledge. Like, if you've ever listened to somebody who never expand their knowledge, they don't sound different. They're not bringing anything new. Okay. When you see somebody who has a clear understanding of something, that's because they're expanding their knowledge. They're studying. They're doing something they're doing their due diligence. That's why an attorney, in most instances, they get into a routine. And most attorneys do not ever go to trial. You see what I'm saying? Because most cases settle out of trial. So if you never go to trial, how you gonna know how to handle a trial? How you gonna know what you need to prepare for? Okay, prompt and diligent. A lawyer should maintain communication with a client concerning the representation. A lawyer should keep in confidence information relating to the representation of a client, except as far as disclose, is required or permitted or other law. A lawyer should conform to requirements of the law. That's why they have a duty to the court. Okay. They have to conform to the law. Okay. So they have to uphold the law. Okay. Both in professional service to clients and in the lawyer's business and professional affairs. The lawyer should use the law's procedures only for a legitimate purpose and not to harass or intimidate others. Now we know they don't do that. Some lawyers will harass you, some lawyers will intimidate you. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. While it is a lawyer's duty, when necessary, to challenge the rectitude of official action, it is also the lawyer's duty to uphold legal process. So that means their duty is really to uphold the legal process. It can't be to the client. So you see, when you see corpus juris secundum, where it says this, right? His duty is to the courts and the public, not to the client. The reason why it says it is because, as it says on the ABA association, that his duty should be to uphold the law, meaning to follow the rules of court, follow the rules of civil procedure, and to make sure that the law is upheld. That's why his duty is to the court and not to the client. Okay, so he's supposed to be unbiased, but just follow the law. That's really what a judge is supposed to do. But we notice that most judges don't do that. They act unfair and impartial. But there's a reason why. It's because most people don't understand law. So you go into court and you hear all this stuff on the internet, and then you start doing all this crazy stuff. So then the judge is like, this guy's incompetent. I don't have time for this today. So look, as a public citizen, a lawyer should seek improvement of law, and we know they don't do that. By seeking improvement of law, what they do in modern day culture is try to heighten penalties. So they try to reward the courts and the states. That's really what they do. The administration of justice and the quality of service rendered by a legal professional. As a member of a learned profession, a lawyer should cultivate knowledge of the law beyond its use for clients, employ that knowledge in reform of the law, and work to strengthen legal education. Now, here's the thing. A lot of people who are on here talking, oh, the lawyers is this and lawyers is that. They don't understand that there's a lot of great publications by lawyers that put a lot of people in the so-called patriot movement, a lot of Moors, a lot of people in movements on knowledge. You see what I'm saying? So there are good attorneys, just like there are bad attorneys. You're always going to have good or bad, regardless of what a person's position is. So, in addition, a lawyer should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions and constitutional democracy. Okay, there is no constitutional democracy. The United States is a republic. It's not a democracy. But yeah. Depend on popular participation and support to maintain their authority. See, they're talking about the democracy. They're not talking about the republic. So you have to be wary of these people because they're talking about upholding a democracy, and the Constitution talks about a republic form of government, not a democracy. Okay, a lawyer should be mindful of deficiencies in the administration of justice, and of the fact that the poor and sometimes persons who are not poor cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all of those who become who, because of economic, social barriers, cannot afford or secure adequate legal counsel. A lawyer should aid the legal profession, in pursuing these objectives, and should help the bar regulate itself in the public interest. So when they're talking about the public interest, they're talking about the public trust. They're not talking about your private rights. Okay. So I want you guys to understand that. So we're going to get to, where is it at? All right, we're going to get to 10. The legal profession is largely self-governing. Yeah, it's self-governing. That means that, yeah, okay, we're not even going to get into that. We all know that. Okay. Although other professionals also have been granted powers of self-government, the legal profession is unique in this respect because the close relationship between the profession and the process of government and law enforcement, this connection is manifested in the fact the ultimate authority over the legal profession is vested largely in the courts. So that the lawyer has to yield to the court, not their client. It's not nefarious. You see what I'm saying? It's just that, say if a client did something and the lawyer knows it and it's against his conscience to represent the client, he should be able to step down, in my opinion. And he, in most instances, he can remove himself due to ethical issues or whatever. He can remove his appearance. But I wanted to go over this so you guys kind of have a clear understanding and kind of inform you, with my experience with a lot of lawyers. I remember one time I had a case, and this was in West Palm Beach, where a lawyer, wait, no, this is in Broward. Sorry, my bad. Uh, a lawyer hired another lawyer, and the lawyer that he hired basically shook hands with my lawyer because the lawyer was he was an out of town real estate investor. He hired a attorney, and the attorney he hired shook hands with my attorney, meaning I was working for the bank. And they basically was like, he's like, I'm not objecting to nothing. I'm not, I'm not doing anything. I tried to tell him, just let it go forward because most attorneys do not know how to get a free house. They do not know how to discharge a mortgage. That's why they'll tell you to bring up all these arguments and go into court and do all these arguments and all this other stuff. They don't know how to get a house free and clear. They never would know how to get a house free and clear because if they did, they wouldn't be attorneys. And with that being said, I'm out.